2010. Seems today's divorced couples are still happy to unite as a family. More and more, it's collaborative law is what it is. It's collaborative arrangements. And according to federal government's child support guidelines, with shared custody arrangement, a parent must exercise access to or have physical custody to the children for 40% more of the time in 1 year. This is happening more and more, according to the folks at the Shulman Family Law. And Daniel Simard is an associate with the Shulman Family Law. You've been seeing this trend over, the last half dozen years, maybe?
Yeah, that's correct, Ted.
Why is that?
Well, I think one of the reasons it's a key reason, and the courts are actually supporting this as well. In 2015, there was an Ontario Court of Appeal decision from Justice Mary Lou Benotto, where she concluded that for many years now, the courts have been trying to move away from the highly charged terminology of custody and access, and mainly because it creates an adversarial approach, creating winners and losers, which is not really in the best interests of children.
Yeah, because they end up, quite frankly, to be the loser in the big picture.
That's exactly correct.
So when you sit down, do you sit down with the husband and the wife simultaneously?
No, that would be a conflict of interest. So generally speaking, if we do have that type of a setup, it's collaborative, like you said in the introduction, but both parties would have their individual counsel with them.
Right. So you're seeing how many people, what is the percentage? Has there been a shift as to where the children go? These are children under the age of 18. Are they still primarily going with their mother?
Well, it's hard to say statistics, but I would say in general there probably is a tendency for children to be with their mothers more than fathers, but that has definitely been shifting. And there's, like we've been talking, there's a shift towards having a shared parenting arrangement where possible.
Mm-hmm. So when you're approached by a client who may not be as at ease with this concept and is more adversarial, looking more for that win-loss situation, how do you convince them to think otherwise?
Well, the first key point is getting the parent to focus on what's in the best interest of the child, and that's what the courts look at as well. So we try to shift away and remove the emotional aspects, which are very high coming off a separation, and say, well, look, this is what's in the best interest of the child. Was the child, or was the father or was the mother deeply involved in the child's life prior to the separation? And the answer to that question is usually yes. So then what's the real reason here, other than emotions, to have that involvement removed post-separation?
Mm-hmm.
So we try to do what we can to let the prospective client think about and remove the emotional aspect and focus on the child's best interest.
In my notes here, it suggests here that part of your process of shared custody is to identify one of the two parties as the final decision maker, coupled with a requirement that there be full information sharing between the parents on all matters relating to the child's welfare and well-being. When it boils down to one of the parents has to be the final decision maker, that's not as collaborative as it should be, is it?
Well, yeah, that's an option. Now, so we can have shared parenting where both parties are making the decision. It's where you can't ultimately get a 50-50 agreement on custody here. So we promote both parties having equal access, equal rights to all information, but when a decision can't be agreed upon, instead of going to a long, prolonged trial, we suggest, well, why don't we put a clause in there that if both parties can't come to an ultimate agreement, then one party gets the ultimate decision-making authority here. But that's not necessarily the preferred approach. That's when there's conflict, and we're trying to avoid a trial here.
Sounds very promising.
Certainly, and I think costs, legal costs, which have also been in the news recently, have played a role in it. It's just getting very costly to litigate, and this has actually been, having a positive effect on the outcome of child relationships and child arrangements.
All right. Daniel, thank you very much for your time. Have a great weekend.
Oh, thank you very much, Ted. You too.
Daniel Simard is an associate at the Shulman Family Law. Coming up, Peter Wildman and Paul Chatto from the Frantics. Stay tuned. Don't go away. Trust me. It is 2:26. Frantics. Stay tuned.